want to commend both council for their excellent representations on behalf of their respective clients. I want to thank city staff for their assistance and our very able board counsel for her assistance. I'm going to ask Vice Chair Skoglund to provide us his thoughts, but in doing that, I think it'd be useful for him to provide a summary of his background before that, so we sort of have a sense of what information he brings to this hearing, and I will do the same. Vice Chair Skoglund, can you please proceed?
Thank you, Chair. I was asked a couple of days ago if I was an attorney. I am not. Thought about it once, but I'm not. My background is primarily human resources, as in close to 30 years, 20 of those 30 in the top human resource position in the companies I was with. My companies included Victoria's Secret, where I was Executive Vice President, responsible for human resources, American Eagle Outfitters, where I was Senior VP over all HR activity. And other than that, I served in capacities that dealt with operations. Some of you may remember a company called High Health that had various stores. I was VP of operations and sales for them. When I spoke 6 years ago with the City Council regarding a position on a personnel board, I made an effort to explain to them that the retail companies I was with, I basically saw it all. I saw it all from infractions, I saw it all from disciplines. It was from levels of sales people to presidents. And there's not much that surprises me anymore, other than poor decisions, poor judgment, and the result of those. But my point is, I've been through a lot of disciplinary activity. I've been through a lot of infractions. I convinced the city that I had enough substance there to be of value in proceedings like this.
Thank you. And your thoughts on this matter?
My thoughts begin with my understanding of my responsibility. My responsibility is to examine the merit of the stated violations for which Aaron Minor was dismissed, the outcome of other internal investigations, discipline of other parties, how related activities could have been performed differently. Really, while I have strong opinions, it has no bearing on my responsibility and decision today. Put another way, inconsistencies or disparate treatments of other things that have come to light here are concernful, but not applicable. The City of Scottsdale found the following violations in the conduct of Aaron Minor. Scottsdale Revised Code, Section 1472, subsection 8, there are reasonable grounds to believe that the employee has knowingly made a false statement or falsified any document, report, or statement relating to their employment with the city or any administrative investigation. 20, the employee has violated an ordinance, written policy, or administrative regulation of the city. Number 30, an employee working for the Scottsdale Police Department has violated provisions of general orders or operation orders of the police department. And 35, the employee has knowingly and intentionally engaged in behavior that violate the city's stated values. Specifically, General Orders 1411-2 requires employees to answer truthfully and completely. During the IA interview of June 28, 2019, Aaron Minor was neither truthful or complete with his testimony. It is clear from his exchanges with Lieutenant Bonnet on the late afternoon/early evening of May 9th, and his phone conversations with Assistant Chief Pop on May 10th, and in a meeting on May 14th, that he had information about offended parties, specifically himself and Lieutenant Bonnet. Other testimony confirms Mr. Minor was both shocked and offended. His own testimony today reveals that prior to his June 28th interview, he knew of many offended people. He further said 10 to 12. None of this was provided in that IA interview. Police General Orders 2503, which prohibits failure to accurately report all facts pertaining to an investigation of other matter concerned to the department, or relating a false, deceptive, or misleading account of an incident or fact at issue in an investigation of other matter of concern to the department. Aaron Minor's conversations with Assistant Chief Slavin on May 10th and Assistant Chief Pop on May 10th and 14th would have been facts of value to the investigation. Failure to report all facts during the June 28th interview provided an inaccurate, incomplete, and misleading testimony. Administrative Regulation 320, Ethical Standards, 3.3, maintain personal integrity, specifically 3.3.1, maintain high standards of personal integrity, truthfulness, and fairness. There is a clear integrity violation with the untruthfulness and incompleteness of Mr. Minor's IA interview of June 28, 2019. When asked if there was someone who you knew for sure was directly offended, he responded, "I don't know specifically." And when asked a second time, the response was, "Yeah, not, no." And lastly, city employee values to be accountable and act with integrity. Mr. Minor, as stated earlier, failed to demonstrate integrity on June 28, 2019. My conclusions. Just cause requires the employee is informed about possible disciplinary action. Through manuals, general orders, handbooks, not to mention Aaron Minor's experience as an IA investigator and longtime supervisor, he was certainly informed. B, the disciplinary action is reasonably related to the standards of conduct for a professional law enforcement officer. From the review of integrity violations over recent years and the testimony of Chief Ravel, it is clear to me that the discipline is consistent and absolute. Employment ends. C, discipline is supported by a preponderance of evidence that the conduct occurred. There is no doubt in my mind from testimony over 4 days that there was an integrity violation. And lastly, D, the discipline is not excessive and is reasonably related to the seriousness of the offense and the officer's service record. The discipline is consistent with previous integrity violations. I find this matter very unfortunate and incredibly sad. I think Aaron Minor is a man of great integrity. I think he is a loss to the city of Scottsdale as an employee, and I think he's a loss to the police force. I think had he not had a lapse on June 28, 2019, over the next 2 months he'd be interviewing for Assistant Chief Pop's job instead of no longer being with the force. And all that is very sad. However, I do find a just cause and affirm the actions and discipline taken by the city of Scottsdale.
Thank you, Vice Chair. I will also begin by giving a brief summary of my background. I am an attorney, have been since 1974. As an attorney with the U.S. Department of Labor in Washington, D.C., and New York City, I work with federal investigators. We was the Office of Special Investigations that was merged into the Inspector General's office, investigators in New York City. As an attorney in private practice, I conducted and reviewed workplace discrimination investigations on behalf of employers. I have attended and given seminars on how to conduct workplace discrimination investigations. I've taught employment discrimination law and professional responsibility courses in law school. Due to my background, training, and experience, because some of my questioning may have left the impression that I might consider matters not properly before the board, I want to be clear that my decision today is unaffected by any matters that should not properly be considered by the board. In making my decision, I considered solely what the city proved by a preponderance of the evidence that the appellant knowingly or intentionally lied or provided false or misleading information in the two internal affairs investigations. I'm cognizant of the fact that the board is to determine whether or not just cause existed for the disciplinary action set forth in ARS section 38-11 In making my decision, I'm also aware of the provisions of the Arizona Revised Statute section 38-1107. I'm sorry, 38-1101, subpart 7. I've reviewed the city's reasons for terminating appellant set forth in the letter of dismissal, the Human Resources Director's statement contained in the Personnel Board member findings and fact sheet, which was very helpful in setting forth the provisions of the Scottsdale Revised Code, general orders, city administrative regulations, and the city employee values. Most importantly, I consider the material and relevant facts and evidence quite ably submitted by both counsel as well as their summations. Based upon my review of all the relevant material evidence, including the exhibits and testimony of witnesses, and considering the burden of proof, it's my considered opinion that the determination of the city to terminate the appellant was incorrect and should be overruled. The bottom of the question before the board is whether the appellant knowingly made a false statement in the investigations. Very respectfully, highly respectfully disagree with the vice chair. Because of that disagreement, I do not find that he violated any provisions of the code, Scottsdale Code, general orders, administrative regulations, or the city employee values or the statute. The primary basis of this decision, and what we're really here to decide, is the appellant's intent of his testimony. The appellant's testimony, I believe, was more than sufficient to show he was not knowingly or intentionally lying or providing false or misleading information. He recently, in his testimony, explained why he answered what was a narrow question the way he did. In his telling, when he was first asked the question, not in the context of who to speak with next, he did not identify himself. That to me indicates lack of clarity whether it was known or not at the time. Sometimes not thinking that much. He had no motivation to lie. He had provided all of that information through the chain of command. And by the time of the first interview, he was aware that many staff people were offended. That's correct. But I think it defies common sense. And particularly there was evidence, testimony that he had some animosity towards Assistant Chief Slavery. That he would have taken any opportunity he felt to just unload on Assistant Chief Slavery if he understood the question that has been proposed during this hearing and how others understood it. And he did not. It shows to me that he simply, one, was not out to get Chief Slavin, and he didn't understand the question that was being asked towards him. And, well, let me put it a different way. He understood the question. He just did not understand it as many purport to have understood it. Directly offended is different from asking someone if anyone is offended. Directly modifies the word offended. His explanation that he thought the question referred to someone who was actually pointed out during the meeting, which was only Lieutenant Myers, to me, gives the proper answer. The question then becomes, why did he talk about everyone else? He was talking to, in the interim between May 9th and his first interview. It wasn't asked that question. And it's my opinion that the failure to go back on the record, keep the tape rolling, caused this situation. At that point, the interview ended. The transcript is to me, fairly clear that the interview ended somewhat abruptly. And he wanted to talk more, and Sergeant Lewis essentially did not want to hear more. So consequently, in my decision that the city did not have just cause to terminate, I would recommend appropriate relief, which would include back pay and other appropriate matters. I think that also, just checking some notes, additional notes I have. It's clear that he wanted the matter investigated, so it was certainly in his interest to provide additional names, but he didn't based upon his understanding of the question. So my conclusion would be that the decision should be overruled, the felon return to duty, and appropriate damages be awarded. So, where does that leave us? I believe that we have to adopt findings of facts and conclusions of law as set forth in item 5 under the notice of the agenda and provide a recommendation to the city manager. We need to have a formal motion for that. I will ask the vice chair, and I will tell the vice chair, I think this is appropriate. That I've heard what you've said, and I understand it completely. I just think we have a different view on this. I'm wondering if anything I have said has changed your view.
Now, clearly, this personnel board is defined to be 3 people, and there's a reason for that. I further understand that we do not have any final powers, that the conclusions and recommendations that we have go to the city manager for further consideration. And it's up to that individual to then take action based upon what we provide. But I would think that we provide the finding of fact comments to both of us, and there will be information that he will put to good use.
Let me ask you if I can have a motion to go into executive session to see legal counsel.
So moved.
Second, all in favor?
Aye.
Let's go on for the record.